Appeal in the matter of UnipolSai Assicurazioni S.p.A. and Covéa Insurance Plc.
My Lords, I appear in this appeal with Miss Rani Noakes and the respondent, Covéa Insurance. Is represented by Mr. Alistair Schaff and Mr. Simon Carr. My Lord, we've taken the liberty of having our juniors sit beside us. I hope that's not too forward of us. But if your Lordship is content with that, rather than having them sitting behind us, it's just more convenient for us. That's fine. My Lord, as you're aware, this appeal arises out of the order made by Mr. Justice Foxton in two appeals, of which our appeal is listed first, the other being the Markel appeal, to which there is obviously extensive reference in the judgment. That appeal, as you know, was settled after skeletons were served and exchanged. And so there is reference to it in the skeletons. And some of the arguments and parts of the decision and the award in that award are relevant to our appeal. And the Markel award is in the supplemental bundle at tab 4, page 37. If needed, the Markel contractual terms, the relevant terms, are a core bundle, tab 5, page 123. The arbitration in this case was concerned with a property catastrophe excess of loss reinsurance, which was written on a losses occurring during basis for the period 1 January to 31 December 2020. The relevant background to the arbitration, taking it very briefly, is that Covéa had insured a large number of children's nurseries pursuant to a standard nursery care policy, which included a non-damage prevention of access clause, which you will see at supplementary bundle 1, it's set out in the award, supplementary bundle page 12, at paragraph 37. Interruption or interference with the childcare business in consequence of access to the premises being hindered or prevented as a result of the actions or advice of government or local authority following an emergency which is likely to endanger life or property. And then the maximum indemnity period is stated to be 3 months under the direct policy. And if you turn back a page to page 11, you'll see the definition of the indemnity period in paragraph 33. The period beginning with the date of damage and lasting for the period during which your childcare business is affected as a result of the damage, but not longer than the maximum indemnity period. And I've read that to you because, as you've probably seen, the judge has placed some reliance in his judgment on the assessment provisions in the direct policy.
Were those terms known to the reinsurers at the time of the policy?
My Lord, there was no evidence in relation to that, but it is a standard policy. We would accept that. There's a lot of consideration, obviously, my Lord, in relation to between the experts about the importance of the change in writing to writing non-damage business interruption extension from about the 1990s, and you'll have seen that in the judge's award. And the experts, I think that the expert evidence was to the effect that reinsurers would have been aware of that change.
Yeah.
And
not
the specific terms necessarily.
Of the reassured's policy.
No, quite. There was then a deeming provision set out at paragraph 34, which deemed loss resulting, whereby non-property damage interruption was deemed to be loss resulting from damage to property. On Wednesday, the 18th of March 2020, the Prime Minister announced that nurseries were to close from Friday the 20th of March, save for providing facilities for children of essential workers. And Covéa paid business interruption losses suffered by its insureds between the 20th of March 2020 and the 4th of July, when the nurseries were permitted to reopen. And it then sought to aggregate all of those losses and recover them under its property catastrophe excess of loss reinsurance to the extent that they exceeded the excess. We said that they could not do that because, one, there was not a catastrophe for the purposes of the property catastrophe excess of loss reinsurance, and that even if there was, Covéa could not recover more than the aggregate of the individual, that is to say, day by day, business interruption losses sustained in any given period of 186 hours after the catastrophe, if there was one, commenced. Now, the Covéa Tribunal was required to answer 3 questions of construction, which were set out in paragraph 8 of the award. It's Supplementary Bundle 1, tab 1, Supplementary Bundle, tab 1, page 3. And the first question set out there in paragraph 8 was the outbreak and or propagation and or spread of the COVID-19 pandemic within the UK a catastrophe within the meaning of the condition of the reinsurance, taking account of this being a property catastrophe excess of loss reinsurance and the nature of the causal relationship between the type of individual losses and the catastrophe relied upon. And the Covéa Tribunal answered that first question in the affirmative, and you see that at 104 of this paragraph 104, which is page 31 of the bundle. It said that the outbreak of COVID-19 in the UK reflected in an exponential increase in the number of infections during the period up to and including the 18th of March, was a catastrophe within the meaning of the condition of the reinsurance. The second issue was Covéa's fallback position if they were wrong on issue 1. That is stated in quite lengthy terms in paragraph 8 of the award, but I needn't take you to it.
The event point.
Exactly, my lord. Essentially,
We don't need to worry about that.
we don't need to worry about that at all. Essentially, it was the closure, the order to close a loan on its own, without regard to anything else, was a catastrophe. The third issue before the tribunal arose only if it was held that the outbreak of COVID could qualify and concerned the meaning of the hours clause. And I'll address that after I've dealt with the catastrophe point and come back to that. Before we go any further, I want to show you the facts upon which the tribunal relied for its conclusion that the outbreak of COVID-19 reflected in the exponential increase in cases, number of infections, up to March was a catastrophe. And these are set out at tab 1 of the supplemental bundle at beginning at page 7. And they go through to page 9, conclusion of paragraph 22. And it starts, you'll see, at paragraph 18, they say, for present purposes, it's relevant to record that the agreed chronology reveals a growing sense of crisis during the second half of February 2020, leading to an explosion of cases within the UK during the first half of March 2020, such that by 16 March, the date of the Prime Minister's broadcast, and his advice to avoid non-essential contact and travel, to work from home and to avoid all social venues, the number of cases, along with the predicted rate of exponential increase in infections, were threatening to overwhelm the NHS and to lead to many thousands of deaths. In short, by 18 March, the COVID pandemic had swiftly developed into a disaster engulfing the whole of the UK. Then in paragraphs 19, the tribunal said the crisis developed rapidly, and that it developed rapidly is plain from the agreed chronology, and it referred to a number of events. It referred to 21st of March, January, the Department of Health and Public Health England raising the risk level from very low to low. Over the page, at the bottom of that page, 31 January, 2 patients, Chinese nationals at York University, testing positive. Then a SAGE meeting on the 4th of February 2020, which recorded that while human-to-human transmission outside China could not be ruled out, there was no definitive evidence of a sustained outbreak epidemic elsewhere, although it was now known that most of the introductions of the B1 lineage into the UK went on to cause the first wave of infections after the 4th of February, permitting the onward transmission that led to the explosion of cases, as the tribunal says in line 5 of paragraph 20, the explosion of cases during 2020, in March 2020. And then the tribunal goes on to refer to the, on 2nd of March, first death of a patient, 5th of March, COVID made a notifiable disease in England, 11th, the WHO declared it a pandemic, and the 12th, the government, UK government, moving from contain to delay phase. And then paragraph 21, they come back to the explosion of new cases, as they call it, in the UK in March, forcing a rapid reappraisal of the necessary response to the crisis. And they refer to the SAGE meeting on the 18th of March, and then the government instruction on the 18th of March to close. And then they go on to talk about subsequent events after March, with which the regulation, 21st of March, the lockdown on 23rd of March, and the coronavirus regulations on the 26th of March, and then the reopening on the 4th of July. Now, my lords, there are 3 points to make about this part of the award. First, there was no evidence before the tribunal about the rates of infection in the United Kingdom. So when the tribunal referred to an explosion of cases, as they did on 3 occasions, which I've shown you there, in paragraphs 18, 20, and 21 of the award, they were not basing that on any figures relating to the rate of infections. Now, Covéa could have called evidence on rates of infections. They could have gone presumably to Imperial College or Cambridge University or whoever was looking at the figures at the time, but they did not do so. So when the tribunal talked of an explosion of cases, it's merely their graphic description, and one which they've chosen to put upon the development of the disease. And the same applies when they refer to an exponential increase in the number of infections, as they did twice later on in the award in paragraph 49. It's page 16 of tab 1.
But that's not an error of law.
No, my lord,
We're only concerned with errors of law, Mr.
absolutely, my lord. I'm just identifying what they were describing.
Well, they may have been describing their own, in a sense, their own experience of the whole pandemic.
Well, there's no, but the point, my
Whether or
lord,
not there was any specific evidence to support it.
precisely.
It seems to me that the description they give in these paragraphs is
Well, my lord,
entirely justified.
even if that's right, even if it's right,
That was the position. There
Well-
was an explosion of new cases.
well, that may be one's subjective view, my lord, but
It's
there
not a
wasn't any-
subjective view. It's if you look at what, I mean, okay, it was in another case. If you look at what was said in the divisional court in Arch, that was one of the points.
It spread rapidly, my lord, yes,
It spread
rapidly,
incredibly
widely, and
which is
unpredictably.
why the Prime Minister did what he did when he did it.
Yes,
But there's obviously an issue about whether he should have acted sooner, but the fact is that the reason why he acted when he did was because there'd been an explosion of new cases.
my lord, even,
Anyway.
let's assume that there is an explosion or an exponential increase, although we just make the point there wasn't any evidence before the tribunal in relation to that. All that is saying is that the pandemic was developing in the way which pandemics do. They were describing the very features which cause something to be called a pandemic.
Doesn't stop it from being a catastrophe, though.
My lord, it's,
You might say the hurricane went through the Caribbean in the way in which hurricanes normally do, but what it did to some of those islands is rightly described as a catastrophe.
that's, my lord, that's a different point, with all due respect. The question which has to be considered here is whether the outbreak of COVID reflected in this exponential cases was a catastrophe. Now we're dealing with a disease, a virus which spreads rapidly and widely, as has been held. We're not dealing with something like a hurricane, which is a physical event which damages property. They are not the same beast at all. And what we have here, a pandemic is a pandemic because it affects all the people. It becomes a pandemic because it affects all countries and all populations. And so what the tribunal was doing was describing not an event, but the state of affairs that was a pandemic.
What's the difference?
My lord, the difference,
I mean, why isn't the arrival of what is a physical state of affairs, because people have a virus within them, which surely is a physical state of affairs, why isn't the arrival of that physical state of affairs an event?
because all that is happening, my lord, is when you talk about the spread of the pandemic, is you're describing a particular feature of the state of affairs which is a pandemic.
Well, you're describing the spread of the virus.
Yes, but that is what you're describing what a pandemic does.
Yes, but it's happening. You're describing something that is happening.
You're describing
The
You're
spread
des-
of the virus is
My-
something that happens.
My lord, yes, absolutely. You're describing the transmission of the virus from person to person. So you're describing, in the aggregate, a huge number of occurrences of the virus being transmitted from one person to another, and that person contracting COVID-19. The pandemic is the state of affairs beneath which there are a whole multitude of occurrences of the cases of COVID and the transmission of that.
When do you say that state of affairs happened?
The state of affairs,
The pandemic, the COVID pandemic.
but my lord, it probably started, we think, the best we can put is probably December 2019, early January 2020.
So that's when it happened.
No,
The pandemic happened then?
no, the
When do you say
pandemic,
it happened?
no. I think you asked me when it happened, but no, it's an ongoing state of affairs, which started in late 2019, early 2020, and is still going on to this day.
So when did it happen?
It happened over that entire period. The pandemic, the individual cases.
So throughout that period, the pandemic was a happening. Is that right?
No, because a happening is the individual cases. It's an occurrence or event, is the individual cases of the virus contracted by the individual people.
Aren't we looking for these purposes at what constitutes the catastrophe? And the catastrophe involves the disease in a certain volume.
Well, my lord, you're assuming the very thing in issue, with all due respect, because you say the catastrophe involves the disease in a certain quality.
But I'm asking you, I'm sorry, I'm struggling to understand what your submission is as to when the pandemic happened.
The pandemic is a state of affairs, and it is reflected in people becoming infected with COVID-19. And in this country, those infections occurred from January 2020 and have continued to this day. And the pandemic is that state of affairs.
And it was happening throughout the period that the state of affairs existed.
There were transmissions of the virus throughout that time, yes, and still are.
Thank you.
Now, it is, if we can go to the contractual conditions, which are in tab 9 of the core volume. And condition 1 is obviously the insuring clause, whereby reinsurers agree to indemnify the reinsured up to the limit in excess of
So what page, Mr. Christie?
I'm so sorry, it's page 155, tab 9.
Yeah.
Reinsurers agree to indemnify the reinsured up to the limit in excess of the deductible on account of each and every loss occurrence. And then 2.1, the term loss occurrence shall mean all individual losses arising out of and directly occasioned by one catastrophe. Now, it is, and always has been, our position that the words directly occasioned by require there to be a strong causal link between the individual losses and the catastrophe. And we rely on that regard judgment of Lord Justice Ricks and Scott against Copenhagen Re. Right. Authority, I won't take you to it now. Authorities Bundle 22, page 744, paragraph 68. And our position is that that causal requirement can be satisfied only if the catastrophe is an event or a species of event and not a state of affairs. And that is because, obviously, while a state of affairs is an originating cause, it cannot directly occasion losses. And that proposition was accepted by Mr. Justice Foxton at paragraph 104 of his judgment, which is at tab 5, page 97.
How does one distinguish between an event and a state of affairs, given that it would appear that some of the classic catastrophes occur over a period of time? Are they a state of affairs over that period of time?
Well, my lord, this is an issue which exercised both the tribunal and Mr. Justice Foxton. And if you look at the if you go back to the contract and its condition 2 with the hours clause 2.2, it's page 155 again, and the references to a number of hours being attached to specific insured perils or catastrophes. And I think that's what your lordship's question is.
Yeah, that's as I understand the argument, those periods apply to the underlying losses, not to the period of the insured peril.
My lord, absolutely.
I'm on the question as to whether, in deciding whether something is or is not the insured peril of a catastrophe, there is a hard line to be drawn between something that's described as a state of affairs and something that is described as an event in this context, given that some of these insured perils can clearly exist over a period of time.
That is right. Well, the answer is you have to apply as a stage and as a tool. It's not doesn't provide you with a complete answer. Is that you have to apply the unities test, and the unities test applies according to the contractual context in which you apply it. Now, a lot of these catastrophes, earthquakes, the seismic events and so on, may actually last a very short period of time. Some of them, it may be said, with a hurricane, may last longer than that. But in the contractual context, it doesn't mean to say that it's not an event. It's just an event whose duration in the particular context of this reinsurance is not as specific as some of the seismic events.
It may not be an event. The insured peril in this case isn't defined as an event. It's defined as a catastrophe. And what I'm just seeking to explore with you is why we should determine what does or doesn't amount to a catastrophe by reference to a dichotomy between events and states of affairs, which is not a dichotomy which seems to be inherent in things that are described as catastrophes, floods, hurricanes, riots, civil commotions, and so on. And the word event doesn't appear in the clause. Why do we start from the argument from saying, well, we've got to decide whether what happened in this case is on the one hand an event or on the other hand a state of affairs?
Because, my lord, condition 2.1 provides that the term loss occurrence, the loss occurrence is the collection of losses, obviously. Well, it's all individual losses, have to arise out of and be directly occasioned by one catastrophe.
Yes.
And our argument, and I'll take you to the passage in Scott and Copenhagen, but our argument is that that wording, losses arising out of and directly occasioned by one catastrophe, can only be satisfied if the catastrophe is an event or a species of event.
Can I just talk around things one moment? The COVID pandemic obviously had a beginning. You may argue over exactly when it began, but it had a beginning because there wasn't COVID before and then there was COVID. You say, well, it's never ended, as I understand it.
Yes.
And that means it's a state of affairs rather than an event.
Yes.
Suppose you had a volcanic eruption and the volcano continued to produce lava over years, as could happen in Iceland, say. Yes. Would that mean there wasn't a relevant volcanic eruption?
My Lord, all of that, these examples, and there are myriad examples one can come up with, depend probably on the facts and the expert analysis of what an eruption is actually constituted by an eruption. Now, we'll all imagine when Vesuvius blew its top off and there was Pliny watching it, he would say that's an event. No one would have had any problem with that. But if the lava continues to flow for weeks after that and engulfs Herculaneum, that is not necessarily part of the same event, of the eruption, we would say. But what the driver, the critical driver in condition 2.1 is that wording arising out of and directly occasioned by one catastrophe. And it's, I'll take it to the passage in Scott and Copenhagen. It's, say, authorities tab 22 at paragraph 68. And this, starting at paragraph 67, the submission which was being made on behalf of the syndicates was that the causal link expressed by the phrase arising out of was a weak one, and therefore, and possibly in any event, there was nothing that occurred after the initial invasion of capture that outweighed their significance. And Lord Justice Ricks goes on to say, in my judgment, there's nothing in the authorities to support that submission as a matter of principle. On the contrary, it seems to me that in Dawson's Field and Cortland Sharp, a significant causal relationship was, albeit implicitly, imposed. And then if one goes down to just above the letter E, in the present context, the purpose and scope of the rule has to be found in the concept of aggregation inherent in wording such as arising out of one event. A plurality of losses is to be regarded as a single aggregated loss if they can be sufficiently linked to a single unifying event by being causally connected with it. The aggregating function of such a clause is antagonistic to a weak or loose causal relationship between losses and the required unifying single event. This is the more easily seen by acknowledging that once a merely weak causal connection is required, there is in principle no limit to the theoretical possibility of tracing back to the causes of causes. The question therefore in my judgment comes, is there one event which should be regarded as a cause of these losses, so as to make it appropriate to regard those losses as constituting for the purposes of aggregation under the policy one loss? Lord, we say that.
This was in any one event
Yes.
Case. All
Yeah,
those cases. Dawson's Field, Coal and Sharp, Scotland, Copenhagen, all these cases are arising out of one event cases.
Yes,
And the law's absolutely plain on those. This is arising out of one catastrophe.
yes.
Which is not the same thing at all.
Well, but my lord, it's the same causal requirement which is being
Well, the arising out of is that the words used are different.
Obviously, the words used are different. What we say is that it's the causal relationship of arising out of and direct application cannot be satisfied by state of affairs.
Well, I know you say that.
Yes.
But if one looks at how the word catastrophe is used as a matter of ordinary language, it is often used, or can be used, to describe a very lengthy state of affairs which would not be an event. Let us take, for example, humanitarian conditions in a war zone, famine, drought, those sorts of things. One might perfectly, as a matter of the natural use of language, describe the state of affairs in the Yemen, say at the moment, as a catastrophe in humanitarian terms.
My lord,
It's certainly not an event, but we're not concerned with a policy which is tied to an event.
well, my lord, colloquially, one might describe all sorts of things as a catastrophe.
Isn't that what we've got to decide for the purposes of this policy?
Absolutely, but you can refer to a lot of things as being a catastrophe. The fact that Manchester City lost the FA Cup final was a catastrophe, no doubt, or whatever, for some people.
Possibly, but possibly not.
I know certain people in this room have well-known allegiances, so, but that's using the word catastrophe in a colloquial sense. We've got to decide for the purposes of this particular policy what the way in which a catastrophe is being used.
Yes, and we know that it's at least being used to cover the sort of examples that are given in the hours clause, because
Yes.
we know that those are regarded as catastrophes.
Yes,
And those may be a state of affairs which exists over a period of time.
but not no. I don't accept that. Those are if you look at those the catastrophes listed in condition 2.2. What you have here in Little Roman 1, you have weather fronts essentially, hurricanes, typhoons, windstorms, and so on. And I addressed the point already about the fact that a hurricane may, one has to look at the actual facts relating to any given hurricane to determine how many hurricanes or catastrophes there are.
That may last days, sometimes weeks.
Well, it's probably going to be a matter of evidence, my lord. It may be, and it may well be, that a hurricane lasting, like Hurricane Katrina, which hit landfall in Florida and continued through the Gulf of Mexico right through into Mississippi and hit New Orleans, I think 7 days later and so on. It may well be in the context in which it's occurring and in the context of this policy and the landmass involved in the movement of that particular hurricane, it may well be legitimate to say that that is a hurricane, it's an event, it's a species of event. Where does it occur? It occurs in the Gulf of Mexico and surrounding states. The hurricane is happening, and the time period over it is whatever it is, 7 days. But that is the notion of a catastrophe obviously takes colour from the particular context in which it is used. Now the other ones, my lord, the seismic events in 2 are going to be, we would say, classic short, sharp, sudden and devastating events.
What about little 5, Roman 5, the flood? I mean, that allows for 504 hours, but suppose a flood happens because a levee is breached. So some land is flooded, property is flooded, and then there's a decision, no, it's not worth rebuilding the levee, we'll allow the water to take that bit of land. Is that covered?
Well, my lord, just 2 points. As Lord Justice Popplewell was right to say, the number of hours attached to it is irrelevant because that's just the loss window for the purposes of this. But taking your flood example, and again, these are all going to be extremely fact-specific. When the flood breaches the levee and then flows over surrounding property, The flood, we say, is when it reaches the levee. Now, it may remain there for some period thereafter,
But it ceases to be a flood thereafter, does it?
but the catastrophe is the flood, but you can recover the losses caused by that catastrophe, clean up, all those sorts of things.
When you say the catastrophe is the flood,
Yeah.
you mean, I think, in answer to my question, no, it isn't a flood after the initial bursting. The flood only happens at the moment of bursting, and you wouldn't, as a matter of language, describe the state of affairs of the flooded land as being a flood.
Exactly, my lord.
Is that right?
In fact, in your the language you chose there, flooded land, it's the flood and the flooded land which has been flooded. And so that is the catastrophe. Each of these, and we can go through them, the riots, the flood is obviously all of these examples. One has to look closely, actually, at the underlying nature of the phenomenon in question, because it doesn't just follow because there is a hurricane that it will necessarily be considered as one catastrophe. But what they all have in common, all these catastrophes here, is that they're species of event, and they're physical events, and they have physical effects. And the catastrophe, it is the hallmark of a catastrophe. And because of that, I mean, I come back to the causal requirement. It is because of the nature of the causal requirement that can only be satisfied by something which is an event or a species event, and not a statement of affairs. And my lords, that is what, as we understand it, Mr. Justice Foxton held, and we say correctly held. If you go to paragraph 104 of his judgment, tab 5.
So just before you go there,
Yeah.
your submission is that the causal requirement can only be satisfied if the insured peril is defined as an event.
Or a species of an event.
What about any one cause aggregation clauses? They have a causation requirement, but they aggregate by reference to any one cause, not by reference to events.
Yeah, but they will aggregate.
So that the causation element isn't dependent upon whether it is or isn't an event. It's dependent on what the insured peril is, or the aggregation.
Well, you're absolutely right. Of course, it depends upon the terms of the aggregation clause. But an originating cause aggregating clause is satisfied by any number of causes. You don't need an event.
So how can it be right to submit as you do that the causal requirement in this case can only be satisfied if a catastrophe is an event?
Well,
I think it was your submission, if I read it down.
well, it would not be satisfied by an originating cause, because an originating cause cannot directly occasion losses. It's the cause of them. But it doesn't directly occasion them. And that is what, in my submission, Lord Justice Ricks was saying in the Scott and Copenhagen case. The originating cause is just simply too broad. You can have a whole number of originating causes in relation to something, but it's got to be directly occasioned by the catastrophe. That's our case. It means an event, species of
Your
event.
submission, Mr. Christie, that catastrophe as used in this policy is synonymous with event.
Correct.
So when it says catastrophe, it means event.
Well, a species of event. Yes.
Well, we'll ask the obvious question why it didn't use the word event in that case, but there we are.
Well, my lord, it's covered in some of the background materials.
We have to look at things like dictionary definitions, and what will be said against you is, well, the dictionary definitions include definitions which are not limited by reference to an event.
Correct.
Some of them are, and some of them aren't.
Yeah, correct. Some of them are, and what the dictionary definitions, if we go to those, just taking those out of turn, but they're at page 88.
Judge's judgment, can't we?
Yes, exactly, page 88
Right.
of Mr. Justice Foxton's judgment, paragraph 68. Now, one can argue about, I mean, dictionary events are always going to be a number of definitions there, which are obviously going to be focusing on particular points. But if we look at them, and if you look at the Oxford English dictionary, Oxford English, the OED 68, number 1, final event, 2A, final event, 3A, an event, 3B, okay, it's geology, a sudden violent change in the physical order of things, such as sudden upheaval, and then sudden disaster. And then in the shorter, we don't get event. It's not ubiquitous, the word, we accept that, but all of these things we say, as in revolutionary event there, are what they are connoting. All of them, we say, actually, is a sudden event, actually.
Is Roman 4, sorry, is large 4 limited to sudden disaster? Is it not encompassing sudden disaster, always widespread disaster, always very fatal disaster, always signal disaster? Because as a matter of language, I would have thought a widespread disaster is exactly what one would describe as a catastrophe, whether it was sudden or not.
And the shorter dictionary actually says a sudden or widespread or noteworthy disaster.
Yes. Well, a widespread disaster is going to be a catastrophe. It's going to be something like a flood, or a tidal wave, or a hurricane, and so on.
Or famine or drought.
Well, no, I wouldn't agree with that. Famine or drought, no. We would say, are a state of affairs, and they're certainly not listed here, because they are not. A famine is a description of the fact that over a period of time, a relevant percentage of the population has been
not a widespread
malnourished.
disaster.
In a colloquial sense, of course it is, but it's not a widespread disaster for the purposes of this reinsurance.
I mean, you're seeking to bring into your references to event what is an event for insurance purposes. Because if you leave aside what is an event for insurance purposes, well, a pandemic is an event. I mean, it happened. It's still happening, you say, but it's an event. It's a physical happening. It's a transmission of viruses from one person to another causing illness.
My lord, yes, but you say I'm seeking to bring into the reinsurance, but the definition, as you all know, the definition of an event is drawn from the insurance and reinsurance cases. And if we look at the test case, Authorities Bundle 1.
But just pausing one moment, I mean, when we find references in dictionaries to events, they're not necessarily referring to the insurance approach to event.
No.
In an ordinary sense, a famine is an event, a pandemic is an event. It has a beginning, each of them has a beginning.
My lord, in an ordinary sense, possibly, but you're not dealing with an ordinary sense. You are dealing actually with a contract of reinsurance where the parties have chosen a particular wording because of its usage. They're aware of its history, and they have adopted that particular wording in order.
Sorry, what is the, sorry to interrupt you, but what is the insurance history of the word catastrophe that we have to take account of? I understand that the word event
Yes.
is loaded with
Yes.
meaning in the insurance context.
But,
But is the word catastrophe,
well, the word
does that have any fixed meaning in insurance terms?
Well, as Mr. Justice Foxton reviewed the materials in relation to that, and I mean this is going back to the 1960s and so on. But the word any one catastrophe is a wording which has been around since, I think I'm right in saying, 1969. Sorry. Yes, since 1969, we find that in paragraph 48 of Mr. Justice Foxton. 48 of the judgment, page 79 of the bundle. the word catastrophe, and the LPO 98 wording, which has been around since 1968, drafted apparently by Mr. Robert Kiln, is in, if you look at it, on pages 79 and 80, although there were some additions being made in relation to flood and so on, and there's changes in the hours, that wording is essentially unchanged since 1969.
Well, it wouldn't at all surprise me if catastrophe insurance had been around for a lot longer than that.
Yeah, because,
as an insured peril, but that's slightly different from the point we were on, which is whether it has any settled meaning in insurance, which has been identified.
common ground.
Event obviously does, but catastrophe, I think you're accepting not.
My lord, common ground, there's no settled meaning of the word catastrophe, and you have to look at it in context.
No reported case which deals with it, is there?
No.
I mean, this is, Mr. Justice Foxton is setting out what Mr. Kiln says was his view as to what it meant, and its derivation,
Yes.
which certainly, so far as he was concerned, was the 1962-63 cold winter.
Yes, that's when one of the problems started in relation to this state of affairs, and it happened again.
Well, I'm not sure that's the point. I think he was taking it on the basis that was a catastrophe.
No, I don't think so, my lord. I think if you look back at it's Butler and Merkin at paragraph 47, and there was a dispute after the cold winter 62-63. Which
They settled the claims, didn't they?
they settled the
They settled
claims,
the
yes. But
So we
I
don't
mean,
really know.
the commentary by Mr. Butler suggests that reinsurers were predisposed.
Where's that?
This is on page 79 of the bundle, about 8 lines down. The uncertainty surrounding the permitted aggregation came to a head in the severe winter. Then in these circumstances, reinsurers argued against their reinsurers, etc. And then a couple of lines down, reinsurers for their part resisted these claims on the basis that bad weather constituted a state of affairs rather than an event. So broad aggregation of losses was not permissible. Eventual claims were compromised.
The beginning of that paragraph suggests that was that was any one event.
Any one event. And after
Not
that,
as much.
he says the essence of the clause as originally drafted was to provide for the aggregation of there was then a change. Sorry, and then 7 or 8 lines up from the bottom will be noted that the word event was abandoned in favour of the word catastrophe. To make it clear, the intention was to cover happenings that were short, sharp, and devastating. And that was indeed the historical derivation from the San Francisco
So catastrophe cover, at least since the 1906 earthquake.
Yes, yeah. And one sees there, and then if you go on over the page, page 80, in Mr. Kiln's book, paragraph 50, we're in the 1960s, here after his own wording in August 1969, he's describing the understanding at the time, and he says, they used the words occasionally catastrophe because we felt it was more specific. It implied a violent happening which in itself caused damage. The word event, we felt, might have applied to something which might have been the cause of a catastrophe rather than a catastrophe or disaster itself. So that's the background. And Mr. Justice Foxton was not disposed to place much weight on these materials. You'll see his discussion at paragraph 56. Essentially, he says that chronologically and textually they're remote and the link is too tenuous. But in fact, the text of the 1969 wording, which I've just shown you, the Kiln wording, is, aside from the addition of the flood and aside from changes to the number of hours, essentially identical to that wording back in 1969. And what we say, again, except Mr. Foxton, Mr. Foxton and the tribunal did not attach weight to these, but we say they should have done actually, because what they show is actually a continuity in the approach to and the treatment of the word catastrophe going back to the 1960s, and something which, albeit there's no settled meaning, is part of the relevant factual matrix and informs the reader of what was understood by a catastrophe, and that's a short, sharp, devastating event. Or as Mr. Kiln says, a violent happening which in itself caused damage. My Lord, that's maybe a long way of answering your question about why we say a catastrophe is an event. But we say it's compelled by the causal requirement, but it's actually supported. It's supported by the background, and it's supported by the wording of the reinsurance contract itself. Supported, we say, in that listing of 14 separate perils in condition 2.2, the hours clause. And there's an argument, you'll have seen the Eustem generis argument in relation to condition 2.2.7 of the policy, because what is relied upon here is the wording of whatsoever nature. And we say in relation to that, and I can deal with this point quickly here, it's page 156 of the bundle. 168 hours for any loss occurrence of whatsoever nature, which does not include individual loss or losses. And it's said that by Covéa that the outbreak of COVID, reflected in the exponential number of cases, comes within 2.7. And we say 2.7 does not apply. 2.7 comes after this list of 14 perils which are all physical, with physical effects. And what it is doing is saying that there can be other catastrophes or insured perils, but they have to be of the same class or tribe as is used in that judgment of Lord Justice Evans, BOC sentient, which we've referred to. It's the same class or tribe as what has gone before. And what is here, we're in the realm of property damage, physical event having physical effects.
Sorry, what did you say is the characteristic of the genus?
The genus.
They're all sudden?
No,
they're all events?
it's a physical event having physical effects.
Physical effects on property, not people.
Well, I mean, catastrophe, a hurricane will obviously damage people, but it's a property damage policy, yes.
But what about if someone gets struck by lightning?
Well,
Not a catastrophe?
well, no, that wouldn't be a catastrophe, my lord, no.
But if a building got struck by lightning, it would.
If it's covered as one of the, you would have to bring yourself, it could be, yes.
So I just understand, Mr. Christie, is that a submission that this policy, this reinsurance doesn't cover non-property damage BI at all?
Correct.
Even though it says that it is to indemnify in respect of all business written in the reinsurance property department, classified as household and commercial, and that there is an unfettered discretion as to what business is written in that class.
Yes. And my Lord, there was a lot of attention given to this both in the award and by Mr. Justice Foxton, because they both relied upon the fact that since the 1990s these non-damage business interruption extensions had become commonplace. And essentially the argument was, because it's in the underlying, therefore it must have been the intention of the parties that it's covered under the reinsurance as well. And we say that is completely wrong and a completely heterodox approach. And we rely upon the judgment of Lord Mustel in Axon Field in relation to this point, and it is an important point. Can I just show you, you'll be familiar with that, but can I just show you the paragraphs we rely upon in Axon Field? Sorry, it's my fault, I'm moving around.
What page?
It's tab 10 and it's at page 428. Now, obviously, this case was dealing with a case where there were two aggregation clauses, one at the direct level, which had been considered in Cox and Bankside, which was an originating cause aggregation clause, and at the reinsurance level, arising from one event, a different wording. So the court said, just because you've got the originating cause, you can't assume that the arising from one event language can be interpreted the same way. But we say, and if you pick it up at the bottom of 428, the letter H, prominent among the reasons given were three themes whose importance extends beyond this particular dispute. And since I ventured to differ from each, I'll turn to them straight away. The first is an assumption that where a direct insurer takes out reinsurance, and where both policies contain provisions enabling the amount of losses to be added together, the parties are likely to have intended their effect to be much the same. The assumption may very well be correct with the reinsurances of the proportionate kind, under which the reinsurer is sharing the risk assumed by the direct insurer. In such an event, it is indeed likely that the treatment of multiple losses, and hence the outcome of the parallel contracts, was meant to be the same. But where a reinsurer writes an excess of loss treaty for a layer of the whole account, or the whole of a stipulated account of the reinsured, I see no reason to assume that aggregation clauses in one are intended to have the same effect as aggregation clauses in the other. The insurances are not in any real sense back to back. My lords, that is, and he goes on to discuss the completely different strategies which are adopted by an insurer writing at the direct level and a reinsurer at the reinsurance level, because their considerations and the way they go about writing the risk is totally different. And we say the same where the judge fell into error here and the tribunal was in taking the fact that underlying business had been expanded to include non-damage business interruption, taking that fact and concluding on the basis of the fact that it was written and comprised all part of the all business in the category of the class of business, therefore it was covered under the reinsurance without going through the anterior process of asking themselves or himself what was the reinsurance actually covering.
I understand that point, but is your submission that this reinsurance can never cover non-damage business interruption, but can, I think you would say, cover business interruption where there is physical damage?
Correct.
And just unpacking that a moment longer, going back to the person who's hit by lightning. Suppose there's a hurricane, and one flash of lightning destroys a building. Then, if your business is interrupted, you can get some consequential loss, not just damage to the building, as I understand it.
Yes.
Suppose instead that another flash of lightning kills a key employee, so that for the coming weeks you can't carry on your business. That's not covered?
My lord, that would be, well, it would be, that could be covered. It wouldn't be a non-damage. It would be, I suppose it would depend upon the coverage under the underlying policy. If the underlying policy contained cover for personal injury.
Even though we're not really talking about personal injury, we're talking about damage to the business. You found that because your key employee has been killed, forget about it, the fact that he might have something to complain about, or his estate might have something to complain about, your business has been knocked for a period.
No, that would not be covered under this, because you'd have to have physical damage
The property.
to property.
And that's simply a matter of the construction of the word catastrophe.
Correct.
Even though it's the same hurricane that's destroyed the building or destroyed the person.
Yes, but I mean, it's no surprise. That's why catastrophe excess of loss reinsurers typically get less premium than whole account, because they're only agreeing to reinsure a specific segment of the overall account.
So a fire which reaches the very border of a nursery, it is a catastrophe if it singes some of the wall, and is not a catastrophe if it stops short, but the council have closed the premises anyway.
Correct. If and I think the other example.
How can that be right as a description of the fire as to whether the fire is or isn't a catastrophe?
Well,
That's simply a consequence of the loss it causes, not whether you would properly describe it as a catastrophe.
well, it's whether or not it's covered under this contract.
Yes, well, yes,
Yeah,
it's whether it's not. It's something that's meant by a catastrophe. And you say it's a catastrophe if it goes just far enough to cause some physical damage, but it's not a catastrophe if it's just short of it, but the school is closed.
Correct, because in those circumstances, if the fire comes up within 6 feet of the building, but doesn't cause any property damage, and miraculously stops or is extinguished, the problem has been averted. It's gone. And the fact that the building may
May
be...
not have gone. My example to you was that the problem hasn't gone. There's a direct causative link between that fire and the loss, because the school is closed because of the fire potentially reaching it. We're not here looking at causation or loss. We're looking at the nature of something, whether it is or isn't a catastrophe.
No, in the ordinary run of events, if there is no physical damage and the building or whatever is closed by government order, there is no cover under this policy. And the only way you get cover under this policy, in fact, in respect of civil action, is through condition 18 of the policy, which refers to civil action and specifically provides, by way of extension to cover for loss or damage, physical loss or damage covered by civil authority action. It's quite a narrow form of cover, but that is where the cover is, and there is not otherwise cover. My lords, I'm sort of halfway through my time, so I must move on to the hours clause. But before I do so, I just wanted to just show you the passage in Supreme Court in the FCA test case, with which I'm sure you're familiar. It's bundled, it's tab 1 of the authorities, page 48.
Page
48, paragraph 69. So, a disease that spreads is not something that occurs at a particular time and place in a particular way. It occurs at a multiplicity of different times and places and may occur in different ways involving differing symptoms of greater or lesser severity. Nor, for that matter, could an outbreak of disease be regarded as one occurrence, unless the individual cases of disease described as an outbreak have a sufficient degree of unity in relation to time, locality, and cause. If several members of a household were all infected with COVID-19 when a carrier of the disease visited their home on a particular day, that might arguably be described as one occurrence, but the same could not be said of the contraction of the disease by different individuals on different days, from different towns and from different sources. Still less could it be said that all the cases of COVID-19 in England or the United Kingdom or throughout the world, which had arisen by any given date in March 2020, constituted one occurrence. On any reasonable or realistic view, those cases comprised thousands of separate occurrences of COVID. Now, my Lord, just before I leave this topic, what Mr. Justice Foxton has held at paragraph 104, correctly, we say, if I can ask you to, it's at page 97 of the bundle.
Yeah.
He says, it's not necessary for the purpose of disposing of these bills to provide a definition of catastrophe which can demarcate these distinct scenarios for all purposes, even assuming it's possible to do so. The answer is likely to be heavily dependent on the commercial and contractual context in which it arises, which is one of the issues which we have discussed in relation to things like floods and hurricanes. However, in the context under consideration here, I'm satisfied of the following. The catastrophe must be something capable of directly causing individual losses, because that is what both ours clauses require. That requirement of itself is likely in most, if not all, foreseeable scenarios to exclude attempts to aggregate by reference to what are often described in aggregation disputes as states of affairs. The catastrophe must be something which, in the context of terms of the reinsurances in which the term appears, can fairly be regarded as a coherent, particular, and readily identifiable happening with an existence, identity, and catastrophic character, which arises from more than the mere fact that it causes substantial losses. 3, to that extent, it ought to be possible, in a broad sense, to identify when the catastrophe comes into existence and ceases to be, even if an attempt at a precise temporal delineation would offer scope for legitimate debate and dispute. Catastrophe will involve an adverse change on a significant scale from that which preceded it. And, my lords, the short point is, if you put together what Mr. Justice Foxton has held correctly, we say, and the judgment of the Supreme Court, which is saying that an outbreak of COVID cannot be an event, it must follow. And a pandemic cannot be an event or occurrence. It must follow that the pandemic cannot be a catastrophe. And by the same token, if the pandemic cannot be a catastrophe, no single isolated part of it, whether by reference to 2 or 3 weeks or whatever.
So do you say that the judge was right, at paragraph 104?
Paragraph 104, he's correct, yes. He's correctly identified the fact that it cannot be a state of affairs. And the Supreme Court has held that COVID-19 as a whole is not an occurrence. And we say what it is, it's implicit in that it is a state of affairs.
He's not relying on the state of affairs terminology, is he?
Who?
The judge. You say he's correctly held that it can't be a state of affairs, but he doesn't use that term. He says the explanation he's giving will knock out most things that would be described as states of affairs, but he's not saying for this purpose there is a distinction between an event and the state of affairs. He's approaching it differently.
Well, my lord, I think he must be taken to have had the distinction between an event and a state of affairs, which is drawn in cases like Caudle and Sharp very firmly at the front of his mind. And in Caudle and Sharp, as you recollect, the issue there was the underwriter's decision to write 32 run-off contracts, and for the purposes of reinsurance by reference to any one event, it was being argued that the event was the underwriter's state of mind. It was his negligent error, his blind spot in failing to understand the consequences of the asbestosis claims which were coming in.
Do you
Sorry, my lord, I didn't mean to, but the very clear distinction being drawn there between an event and a state of affairs, and the Court of Appeal, of course, overruled both the arbitrators and the judge and held that Mr. Athwaite's blind spot was a state of affairs, it was not an event. So Mr. Justice Foxton must surely have had that in his mind.
Do you understand the distinction you're referring to there as corresponding precisely to Mr. Justice Foxton's reference to a coherent, particular and readily identifiable happening?
Yes, and he refers to it not just there, my lord, but back earlier at paragraph 95, where he's talking about the, it seems to have in mind the unities test. He refers to a radical discontinuity with what went before, which appealed to the Markel Tribunal. And he says, contemplates the ability to distinguish between the period when the catastrophe is existence and when it's not. This can be seen as an aspect of the distinction discussed under the next heading between something which is coherent, particular, and readily identifiable, and a collection of things or a continuing state of affairs. The more diffuse and extended the matter alleged to amount to catastrophe is in the manner in which it arises, the period of existence and the circumstances in which it causes to be, the more difficult it may be to establish a coherent, particular, and identifiable character which a catastrophe will have. Slightly unfortunate because he's used the word catastrophe in a slightly circular sense there, but yes.
You say, despite the elaborate way in which he deals with it, including at paragraph 104, what he has essentially found is that a catastrophe is an event or occurrence.
A species of
event or occurrence, and that's what the judge found.
Right.
And then you say he's right about that, and therefore disease can't be a catastrophe.
Correct. And that's what the Supreme Court has said. If the pandemic can't be a catastrophe, then no particular part of the pandemic can be a catastrophe. And that's the short answer to the point.
It might be said that if that's what he meant, he would have used that language rather than the rather different language he used in paragraph 104.
I mean, the language which he uses in 104.2, for instance, he says it can be fairly regarded as a coherent, particular, and readily identifiable happening.
Yes.
And a happening is, as we know from Kuwait Airlines case, Mr. Justice Ricks, is an event or an occurrence. It's synonymous. So he's talking about an occurrence.
So does Kuwait Airways say anything about the word happening?
It does. It's tab 17, page 656. but the left-hand column, the foot of the left-hand column, it seems to me these authorities,
Which page?
656. This follows a lengthy citation from the award of Mr. Carr QC in the Dawson's Field arbitration. And Mr. Justice Ricks picks it up in the last three lines of the left-hand column of 686. It seems to me these authorities justify the following propositions: an occurrence which is not materially different from an event or happening, unless perchance the contractual context requires some distinction to be made, is not the same as a loss, for one occurrence may embrace a plurality of losses. Nevertheless, the losses circumstances must be scrutinised to see whether they involve such a degree of unity as to justify their being described or as or arising out of one occurrence. And then he goes on to say it may be scrutinised from the point of view of an informed observer. And sorry, Lord Justice Newey, I think you were getting geared up to say something.
I didn't want to interrupt you this time too. Just thinking about what you say about paragraph 104, the judge then goes on to deal with the Covéa award in paragraph 106. And in 106.2 he says, the outbreak described by the tribunal can fairly be regarded as a coherent and discrete happening with an existence, identity and catastrophic character which arise independently of the fact that it causes substantial losses. Now, I think you would say that if you apply arch, that is wrong.
Yes.
Does that suggest that when Mr. Justice Foxton referred in 104.2 to coherent, particular and readily identifiable happening, he didn't mean event in the insurance sense?
Well, we can only take him on the basis of the word he's used. With all due respect, I think one's entitled to assume that he was aware of the importance of the word happening. And we agree with his conclusions in 104. And what has happened is then made the error of law when he comes through to 105, 106, because just like the arbitrators and the judge in Caudle and Sharp, he failed to appreciate the distinction between an event and a state of affairs.
Is the word happening often used as an aggregation in Excel insurance?
I think it's fair to say,
I can't remember having come across it before myself.
Neither can I, my lord.
So the remark of Mr. Justice Ricks equating it with an event or an occurrence may not be talking about it as an aggregation.
Well, I think, I mean, as a matter of ordinary English, what he's using, happening, is something which happens
Well,
at a particular
I
time.
think people would say that COVID was something that happened
as
as a matter of language. Those people would say that COVID happened.
Yeah, but
The pandemic happened.
But these are not reinsurance underwriters who say that. I mean, they will, of course, people will
Which
say
is
that.
why I ask about it a particular insurance context. Because speaking for myself, I think one does have to be a little bit careful about whether one is looking at something which does have an established insurance meaning, such as any one event or originating cause. Very, very well travelled territory, and the parties can be assumed to know what was meant by it.
Yes.
That it had the Dawson's Field definition endorsed from early days. But if one is talking about a catastrophe or a happening or something else which doesn't have a settled meaning as a matter of insurance law, then one just has to fall back on what it means as a matter of natural language, doesn't one?
Well, possibly, but it is being, I mean, Mr. Justice Foxton is using this in the context of describing what a catastrophe is. And he's obviously chosen his words very carefully in this context. And he says the catastrophe must be something which, etc., etc. So, my lord, you've got my submissions on the point that is clearly what it was. And then he went on to make the error of law in failing to have regard to the Supreme Court decision in relation to the pandemic and occurrences. And that, we say, is the fundamental error of law in relation to the catastrophe. My lords, if I can move on to the second part of the appeal. And this concerns the hours clause, which you've looked at already. And the issue here, my lords, in the award paragraph 8, supplementary bundle tab 1, page 4, is stated as follows. So, 1.4, so it's assuming it starts off, if there is a catastrophe, then for the purposes of condition 2, that's of the excess insurance, where the insured first sustains indemnifiable business interruption loss with a nominated 168-hour period, but continues to sustain such loss after the said period, whether continuously or otherwise, does such subsequent loss fall to be aggregated with the loss when the said period as part of a single loss occurrence, and then goes on in the parenthesis, which I needn't read that out. And the tribunal answered that question in the affirmative at paragraph 104, holding in essence that so long as the insured first sustained indemnifiable business interruption loss as a result of a catastrophe within a nominated 168-hour period, and any subsequent loss was attributable to the same catastrophe, those losses fall to be aggregated as one loss occurrence which occurred on day 1. And so the tribunal said that condition 2, which we will need to get out in relation to this, condition 2 limited the duration of the period in which the loss first occurred, limited the period of losses which were recoverable by reference to the date when the loss first occurred to the particular policyholder. And the effect of that was that all of the losses of each of the individual insureds, how many hundreds of nurseries there were aggregated by reference to the loss, the business interruption losses, or the losses suffered from business interruption, suffered on the day when the peril struck. And so they are aggregated into one loss. So you take all the loss of every single, every individual nursery, you regard it as being incurred, all the business interruption loss, whether it's 3 months or whatever, as being as occurring on day 1, and then you add them all into the loss occurrence window. So the loss occurrence window actually ceases to very much affect for business interruption losses, because they all happen on one of the of after the peril strikes. Now, we say that's apart from being completely counterintuitive, being unsupported by anything, we say, in the language of the contract of reinsurance, and actually being contrary to the wording of the contract of reinsurance, is completely wrong. The hours clause, and we're dealing with, I'll take you through quite quickly, just in a minute or two, the specific provisions, but the hours clause, and that's condition 2.2, the hours clause. It is an aggregation clause. Its purpose is to identify which of the losses which have been suffered by the reinsured are properly recoverable under the reinsurance. And it does that by 3 stages. First, it identifies the relevant catastrophe, whether it's a hurricane, flood, or a riot. Secondly, this is condition 2.1, it identifies the individual losses which have been caused by that catastrophe. And thirdly, it allocates those individual losses to a particular window of specified hours depending upon the nature of the catastrophe. And it treats all those individual losses occurring within those specified hours as a single loss occurrence. And so that process of allocation at stage 3, which you see in 2.2, is merely a mechanical process. You've identified the catastrophe, you've identified the losses caused by the catastrophe, and you are now allocating those individual losses to a particular temporal duration. And if you look at condition 2.1, well, 2.1 gives a definition of loss occurrence. And if you read in that definition of loss occurrence into 2.2, it reads, the duration and extent of all individual losses arising out of and directly occasioned by one catastrophe shall be limited to, and then the relevant number of periods. So what is saying that the temporal duration of all the individual losses suffered by the underlying policyholders is limited to the period of 120 hours or so, or whatever it is. It's the temporal duration of the underlying individual losses. Now, business interruption losses are financial losses resulting from interruption with the insured's business. And those financial losses occur at a particular time and in a particular place and a particular way. If a policyholder is interrupted by an event such as closure, and of course we're dealing in this context if you're against me on the catastrophe point. Sure. If the business is interrupted by an event such as closure, then it suffers loss on a day-by-day or hour-by-hour basis for as long as the interruption continues. And it makes no sense to say that in circumstances where a business suffers business interruption losses over a period of 6 months,
If we're dealing with nurseries, as we are, rather than say food outlets or something like that, is it hour by hour or even day by day? It's more likely to be week by week, isn't it?
Month by month. It could be. It could be. There was no evidence in relation to that. I mean, we can rely upon our own what we know about the way nurseries operate, and I think they may take children on a half-day basis. I don't know. Maybe hour by hour, or maybe day by day.
We don't have any evidence. Anecdotally, I asked my daughter, who's involved in that at the moment, who tells me that both the government and private nurseries generally charge on a weekly basis.
On a weekly basis. Yes.
But that may not be a point of great importance.
So here
if this is a
you
clause
say
which
you can aggregate in that example, assuming that they close on the 20th of March. You can aggregate for the first week that they suffer a loss.
If it's 7 days, yes, it's 168
hours,
68 hours, 7 days, yes.
It might actually be the Monday to Friday and then the following Monday and Tuesday, depending on.
And they closed from Friday the 20th, so they probably would be closed over the weekend in any event, which in itself causes problems, because if the loss, according to the tribunal and the judge, is when the peril strikes, then the loss would actually be on Saturday morning, whatever, when it was closed in any event, which goes to one of the reasons which we say this idea of the loss occurring when the peril first strikes doesn't actually work in practice.
In real terms, it's the following Monday.
Exactly. So it's not right to say, I mean, that the loss first occurs when the peril strikes. I mean, an answer, I suppose, may be that Mr. Schaff will no doubt develop an answer in relation to that. But it's the same problem which we identified with this whole analysis of the loss occurring when the peril first strikes, with the position of policyholders who run a business and they happen to be on holiday when the peril strikes. there's no loss at all. The loss isn't incurred until they return from holiday some 2 weeks later. And so it's wrong to say that the loss occurs when the peril strikes. But we would say in the nursery example, it may well be that you take children on a weekly basis and their losses would be over the 7-day period. And what you have to look at is the losses on a day-by-day, the business interruption, the losses caused by business interruption on a day-by-day basis over that 7-day period. And that is what is covered, and that is what is allocated to the relevant loss occurrence window. And that approach, we say, is entirely consistent with the indemnity principle. It's only when a loss has occurred on any given day that a right to indemnity arises in respect of that particular loss. Before business interruption has actually occurred, there is no financial loss and no right to indemnity at all. So to take your example of the nursery, there would be no financial loss on the Wednesday following the closure until the Wednesday following the closure. It doesn't occur on the time when the peril strikes. And we say that proposition is self-evident, actually. And it was supported by the Markel Tribunal, as you may have seen. But what the tribunal, the Covéa Tribunal, and the judge have done is to accept really a legal fiction based upon an analogy with the treatment of property damage business interruption losses, which we say has no analytical foundation whatsoever.
Just before you develop it, going back to the people who are on holiday on the 20th of March. So say they're on holiday till the beginning of April. At this stage of the argument, we're assuming there's a catastrophe.
Yes.
So do they have any claim? Do they have a claim for the first week that they're back, or do they have no claim?
We would say, if it is a catastrophe, they would have a claim when they return.
For the first week?
Yes.
Yeah.
So the claim for
Under the underlying policy.
Yes.
But not
Could be
that
aggregated.
could be aggregated for the purposes of the reinsurance, I think you're saying.
yes, it couldn't be aggregated.
In that example, it could be aggregated for the first 2 days. If they're away for the first week and they're back on the 30th of March, so the insurers Covéa pay out
Yes.
for the week of the 30th of March. If the loss occurrence starts on the 23rd of March,
Yes.
then that will pick up 2 days for that particular.
Correct. That would go into that loss occurrence window, and then you could start another loss occurrence window.
But suppose they're away for a fortnight or longer.
Yes,
then
exactly.
you'd say they may well be able to recover under the underlying insurance, but
Yeah.
that doesn't come within the window so as to
Precisely.
be capable of
Absolutely
aggregation.
Yes.
Correct. Now, just going through the the policy conditions which are relevant here. What the general proposition which I'm seeking to make in taking you through these is that what the contract is envisaging and focusing upon is losses which occur at particular times, and that's what it's providing coverage for, losses at particular times in particular places. And so you start with the period clause. This is page 152, the risk details. And you'll see that the contract is written on a loss occurring during basis. And it applies to losses during that period. Both days included local standard time at the place where the loss occurs. So it applies only to losses occurring during the policy period starting on 1 January 2020. It doesn't provide cover for anything outside that, subject to condition 3, which I'll show you in a minute. Now the type, it's a property catastrophe excess of loss reinsurance. That is significant, we say. The class of business is all business. It's not just nurseries, it's commercial properties as well. That may go to an argument about uncommerciality of the cover, because it covers commercial properties. It could cover commercial banks in Canary Wharf, which suffer a power outage, for instance. So those losses, there's an argument about
This is Covéa's business.
yes.
There may be a more general point about this being standard wording, but in this context, it's cover for nurseries.
In this context, but I'm making a more general point, my lord, sorry, it wasn't clear. The class of business is in fact extremely wide. The class of business which may find its way into the reinsurance.
Was there any evidence as to what business Covéa wrote generally?
No.
But on the face of it, it's a policy that covers them for any business written in their
Yes.
Property department.
I thought it was any nursery business or nursery and social care business.
Well, we're only
If it
concerned.
wasn't, why are we talking about nurseries at all?
Well, because it is. Sorry, I think we're probably at cross purposes. The policy which is being issued to these policyholders is a nursery care policy. It's a standard policy for nurseries. But the business which will find its way into the reinsurance is not confined to that. There will
That
be
depends
other.
on what Covéa's business is.
Correct. Yes, absolutely.
But the fact that we're only concerned with nurseries in relation to this claim, which is a COVID claim,
Yes.
rather suggests, and I thought I may have misunderstood, I thought that was the nature of the cover that Covéa wrote.
Yes, it was. My lord,
Not more general thing, otherwise I would expect there to be a lot more. But
If I can help, my lord, it's paragraph 5 of the award on page 2 of the supplemental bundle. The answer to your lordship's question is we have £70 million worth of nursery care losses, but I believe I'm right in saying that there were other risks which generated a bit of an additional claim. But as the arbitrators say, paragraph 5, the final sentence, given the distribution of losses, the original business giving rise to the claims to reinsurance was examined during the hearing solely in relation to the standard care nursery care. I think the answer to my lord's question is that there was other business written by Covéa.
Well, I think they say that 72 million losses plus adjusters' fees. Against this, it's losses under non-nursery care policies amount to 5.9 million
Exactly.
inclusive of fees.
But the whole arbitration was basically
So
conducted.
basically, the vast preponderance of their book is nurseries.
Indeed.
Thank
Well,
you.
which have generated losses from
Yeah,
COVID.
which have generated losses.
Sorry,
Yeah, thank you very much.
So moving on, you'll see its territorial scope as all applies to losses occurring in the United Kingdom, Great Britain, Northern Ireland. The reinstatement provisions, and this is a point here, page 153, which is relied upon by Covéa.
Where's the reinstatement provision?
It starts at 152, my lord, the foot of the page, and goes over the page. And this is relied upon by Covéa. Losses hereunder applied chronologically by date of loss. Now, there wasn't any investigation of how this reinstatement provision works, but it seems to be said, I think it's Covéa's argument, that taking the date of first loss occurrence is supported by this reference to losses applied chronologically by date of loss. We say, actually, chronological application of the date of loss is much easier in the proposition which we advance, namely that the financial loss is incurred at the date it actually occurs. But the next point is that we go into the conditions, because this is where the real inquiry begins. We've looked at condition 1 already. That's just the insuring clause. Condition 2 is, and I've made this point already. Condition 2.1 is dealing with causation, the causation of the losses, and then condition 2.2 is dealing purely with the determination, the allocation of specific losses to the loss occurrence. And I've pointed out that if you interpolate the wording from 2.1 into 2.2, such that it reads the duration and extent of any loss occurrence, the duration and extent of all individual losses arising out of and directly occasioned by one catastrophe shall be limited to 120 hours or whatever. What it is saying is, critically, that the duration and extent of the individual losses means the temporal period of the individual losses arising out of the catastrophe. And it is that period, that temporal period, which is limited by condition 2.1 to the prescribed number of hours. So it's setting a
Well, the duration, I mean, so your point really about reading into 2.2, the words in 2.1. So you say the duration and extent of all individual losses arising out of, etc.
Yes.
So if you're looking at duration and extent, the fact that the loss, an individual loss, actually lasts for 6 months, or however long it
Yes.
was, 3.5 months till the 4th of July, is neither here nor there.
Well, the temporal duration.
Because this policy limits the duration and extent of what's recoverable
Correct.
to the 168 hours.
Correct.
Yeah.
And
the uncommerciality point, well, I suppose one answer is, well, if you wanted something more, you could have paid more premium.
correct. It's Arnold against Britain, Lord Newey.
It's an excessive loss policy, not a
Yes.
greater share.
Yeah, precisely.
Yeah.
And the important point as well is when you come to the end of condition 2.2, after you get all the catastrophes set out, no individual loss from whatever insured peril which occurs outside these periods shall be included in that loss occurrence. And my lords, that similar wording in the Markel case was interpreted correctly, we say, by the Markel Tribunal. It's a supplementary bundle, tab 4, page 54. Page 56. The Markel Tribunal's analysis of the hours clause begins at page 55 and goes on to page 57. I haven't got time to go through that in detail, but you may, it may be worth reading that at greater leisure. But in paragraph 62, what the tribunal said is, secondly, however, the words which follow subclause F, I can give you just so that there's no suggestion that we're referring to the wrong, the Markel policy terms, the relevant terms are at core bundle tab 5, page 126. So what the Markel Tribunal was saying, similar wording to us, identical, no individual loss. The words which follow subclause seem to brook no misunderstanding. No individual loss from whatever peril which occurs outside those periods shall be included in that event. That does not seem to be dealing with causation, but the occurrence within a particular loss. And then if we move on in our wording, if we go to 244, which is on page 157 of our wording in the core bundle, and that says, this is the provision which allows, if the losses extend beyond one loss occurrence window, it gives the reinsured the opportunity to divide the losses into two separate loss occurrences. And it says, in the event that the loss occurrence exhausts the full extent of the reinsurance cover purchased by the reinsured for each loss occurrence in place at the time of the loss occurrence, or the maximum period of consecutive hours permissible is exceeded, the reinsured may divide the loss occurrence into 2 or more loss occurrences, provided that there's no overlap in time between 2 such loss occurrences which involve the same insured peril or combination of insured perils, and 2, no loss occurrence commences earlier than the date and time of the happening of the first recorded individual loss to the reinsured, which forms part of that loss occurrence. And there are 3 points there. The reference to the happening of the first recorded loss can refer only to the loss when it happened at a particular time, in a particular place, in a particular way. The reference as well to first recorded individual loss contemplates that losses might be continuing. And then the third point is, if the Covéa tribunal is correct, this provision is largely redundant in the context of pure BI losses. But the critical point is, it's dividing the loss occurrence, but it can't commence earlier than the date and time of the happening of the first recorded individual loss to the reinsured. And again, a similar provision in Markel. We go back to that award. At page 56 of the supplementary bundle, paragraph 63. That tribunal, it was a similar wording but not identical, because it didn't have the word happening. One can pick that up. I'll just read what it did say, actually. It said, simply said, provided no such period commences earlier than the date and time of the first recorded individual loss to the reinsured in respect to the catastrophe in question. So it didn't have the word happening. But even without that word happening, in paragraph 63, the Markel Tribunal's conclusion says, thirdly, the final paragraph of the Hours clause is significant. The reinsured is given the choice of creating 2 or more events where a catastrophe is of greater duration than the above periods, provided that no period commences earlier than the date and time of the first recorded individual loss. This again emphasizes that the occurrence of loss is the defining matter of a period of losses which make up an event. It's true the paragraph also talks of dividing that catastrophe into 2 or more events where its duration extends beyond the Ars Laudem clause. The clause therefore contemplates both events and catastrophes having durations, but that while a possible confusion goes to reinforce that the idea behind the Ars clause is a period during which losses or catastrophes occur, with the ultimate essence of that idea depending upon the occurrence of the losses. And that supported the Markel's conclusion of Markel Tribunal. If you go from page 57, middle of paragraph 66, it says, this tribunal is mandated to find a solution. It talks about the pragmatic treatment of property damage business interruption losses, and the tribunal is mandated to find a solution in accordance with the contract which the parties have made, doing the best it can. It concludes that the most that Markel can claim in respect to business interruption losses in this case is 168 hours from its first recorded individual loss, etc., etc. And that is, I mean, we said that Markel Tribunal was correct on that point, and obviously correct as a matter of principle. Now, it's said in our case, obviously, that, and there was evidence about this, that the practice in the case of property damage business interruption in the market was to treat or allocate business interruption losses back to the date when the property damage occurred. And that was the agreed evidence before the Covéa Tribunal. Now, that may be the practice in relation to property damage, business interruption, but we say it is analytically wrong and is unsustainable, essentially for the reasons which I have given you, namely that you are dealing with losses caused by business interruption which accrue on a day-to-day basis.
And
that-
do you say that it's a market practice in a pragmatic sense, not a market practice in the sense of a custom, which in a case in which one is dealing with property damage, business interruption loss would be binding as a matter of construction of the clause?
There wasn't any, it's never been suggested that it was a custom which was essentially binding. It was agreed between the two experts that there was a practice that
I
that's.
think undisputed rather than agreed. I think it was Mr. Coates' evidence which was regarded as not having been disputed and therefore
Yes, you're quite
formed
right. Yes.
a finding by the
Yeah.
tribunal. But
But
you treat that as a finding as to what happens pragmatically rather than
Exactly.
anything which would
Yes.
bind anyone as
Exactly.
to the construction in a property business interruption
Right,
case.
and I don't think such an argument about custom and practice, which would have to be fair, notorious and widespread, or whatever the test is, was actually advanced. But we say that it may well be that people have chosen to conduct their affairs in the same way that the reinsurers back in 1962 and 63 chose to pay losses for the cold winter. They've chosen to do that, but if you analyse the provisions of the contract, and particularly condition 2.2 and 2.4, to which I've drawn your attention, we say that the only conclusion which can be drawn is that what the reinsurers are doing was agreeing to aggregate individual losses on a day-by-day basis for the purposes of that condition. There's another provision, condition 3 of the contract talks about it refers to extended expiration. It says if this contract should expire or be terminated while a loss occurrence covered by this contract is in progress, it's understood and agreed that subject to the other terms and conditions of this contract, the reinsurers hereon are responsible as if the entire loss or damage had occurred prior to the expiration and termination of this contract, provided that no part of that loss occurrence is claimed against any renewal or replacement of this contract. Now, this provision, what it's said, because remember, so losses occurring during policy, which ends on the 31st of December, and what it is saying is that if you have a loss occurrence which begins on the 28th of December and goes over, then exceptionally, we will treat the losses which have occurred outside the policy period as being within that loss occurrence and therefore recoverable. And that, we say, is entirely inconsistent with Covéa's approach, which is that the loss is treated as occurring on the day when it first occurs. And it's entirely consistent with our approach, which is in relation to losses which are accruing on a day-to-day basis. Because without this extended expiration clause, those losses wouldn't come within the loss occurrence. So we say that supports.
It would be completely odious if their construction were correct.
Correct. As would.
Yeah.
My lord, as would large parts of condition 2.2 in relation to business interruption losses, because they would all be treated as happening on day one when the peril struck. So you wouldn't need any loss window. So that is in relation to the wording of the contract in that regard. And what we say is the wording alone clearly points to the fact that you are talking about what it's accumulating or aggregating as individual losses, which occur on a day-by-day basis, or a week-by-week basis, or an hour-by-hour basis in the relevant loss occurrence window. Lord, I think there are a number of points which Mr. Schaff has made towards the end of his skeleton, paragraphs 54 to 60, which really, I mean, what the difference between us, I mean, we're just looking at these things from the opposite ends of the telescope, as is not unusual in this sort of dispute. And so when he talks about losses first occurring, we say, well, that's just a wholly inappropriate wording to use. And there's nothing in the contract specifically, critically, I should say, there's nothing in the contract which mandates any loss to be treated as when it first occurs. But that there are a couple of, one of the points which the judge relied upon, and it was at a section of his judgment where he looks at the way in which losses were assessed, might be assessed at the direct level. It starts at 137 of the judgment. At page 109, and goes through to page 112, and the judge sets out a passage from Riley, and sets out there, you can see on page 111 a sort of a standard way of calculating business interruption, and that's just extracted from Riley. Now, we say that the judge relied upon that because what he was wanting to say, or what he was saying, was that you have to look at the way in which the direct losses were assessed at the underlying level, and that has to inform the way in which they are treated at the reinsurance level. And if you don't, if you start cutting up losses into 1 week or 2 weeks or 3 weeks, 504 hours, you end up with a certain lumpiness, he said, and so on, and you don't get the benefit of credits and debits in 3 weeks' time. Well, with all due respect to the judge, we say the analysis of the assessment of business interruption losses at the direct level is irrelevant.
Well, that's the whole point, isn't it? You say this is very interesting as regards the insurance, BI insurance, but completely irrelevant
Correct.
to the construction of a excessive loss reinsurance contract.
Correct. And the same bit, there's an issue Mr. Schaff raised about the sort of unworkability or uncommerciality of having to unpick losses once they've already been assessed by the direct insurer. Well, we say that, I mean, that point just doesn't go anywhere. It's missing the point, because we've only agreed to provide cover for specific work losses, and so if you can calculate or assess losses over a 3-month period, there's no reason why you can't assess them over a 1-week period. And then the last point, is said, emasculation of cover, because NDBI losses, the excess on this policy was 10 million, as you probably remembered. NDBI losses would be very unlikely to reach a £10 million excess. Well, we say that's neither here nor there. Essentially, for the reason articulated by my Lord the Chancellor, where he pointed out, well, that's a matter for Covéa to decide what they want to buy.
Well, it's always going to be the case that particularly with catastrophe excessive loss, there are going to be a whole raft of claims under the underlying policies that don't get picked up by the excessive loss reinsurance because they don't get anywhere near the limits.
Precisely.
And in any event, this covers physical damage.
Yes.
And physical damage, business interruption.
Yes,
as well
exactly.
as non-physical damage, business
Precisely.
interruption. And it's perfectly contemplatable that will easily reach the excess.
My Lords, I've used up 2 hours of my time, and I'm going to keep some back for any submissions in response, but for now, those are my submissions.
Thank you, Mr. Hastings. Yes, Mr.
Thank you, my lords. My lords, I would obviously anticipate spending more time on the hours clause, which is the second question of law rather than the first question.
Yes.
So far, logically, I suspect one has to take it in the same order, unfortunately. I could go straight to the hours clause, but I will make some hopefully fairly brief submissions on the first issue.
I think you should deal with it logically.
Yes, otherwise I fear one gets distracted. My lords, the introductory point, which is obviously of more relevance to the first issue than to the second issue, and hardly needs to be said, is that as an appeal against an arbitration award, your lordships are only concerned with errors of law. And this is primarily relevant to the first issue, although it also has a relevance to the second issue for reasons that I will explain. My lords, you don't need the citation of authorities for a recent decision of this court in various eateries, which my Lord Justice Newey was a member of the court on. It's in your lordship's bundle at tab 5, paragraphs 56 to 59. I'm not going to go to it, my lords. Lord Justice Mayles gave the leading judgment. And the relevant question is whether the tribunal is entitled, those are the words which came as Simmons and Gamble, latched onto by Lord Justice Mayles. Was the arbitration tribunal entitled on a correct application of the relevant legal principles to reach the conclusion that it did? And my lords, so much of my learned friend's attack on the first issue is effectively directed towards either the findings of the arbitrators, insofar as they use words like exponential or explosion, which, as an aside, weren't words that were conjured out of thin air by this experienced tribunal, but words like exponential increase were actually to be found in the Sage Minutes and in the evidence of Sir Patrick Vallance referred to in the agreed statement of facts produced before this arbitration tribunal.
Yeah.
Forget that for a moment. These are factual matters for the tribunal. So primary findings or their evaluation of the facts, equally unassailable, unless effectively that evaluation was necessarily inconsistent with the application of the correct legal test. So, for example, sudden outbreak with a certain coherence by middle March. Maybe that's an evaluative judgment rather than a primary finding, one could debate that. But it's simply not open to my learned friend on this appeal to seek to say, in effect, this is, quotes, a state of affairs, whatever is meant by that, come back to that, rather than the catastrophe as evaluated by this tribunal. So that's the headline point, but it does have a relevance which extends beyond simply those paragraphs which have been shown, 18 to 22 of the award, paragraph 49 of the award, to which I direct your lordship's attention, where effectively the arbitrators drew everything together. This is supplementary bundle 1, paragraph 49, page 16. Where the tribunal say that the tribunal accepts the submission, that if the idea of a sudden disaster is inherent in the meaning of catastrophe, has to be interpreted with relevant flexibility. On such an approach, it is evident that the exponential increase in COVID infections in the UK during the first 3 weeks of March did amount to a disaster of sudden onset, such as to qualify as a catastrophe. Indeed, it can fairly be described as a catastrophe which changed the whole course of life in the UK in March 2020. And then they elaborate, and I'm not going to take time reading this out, but they go through the sort of chronology, and then about 5 or 6 lines down, the instruction to close schools and nurseries that followed 2 days later, the result of a sudden outbreak of disease within the UK. During this relatively short period, the COVID outbreak assumed a certain coherence in its development and effect and gave rise to a profound subversion of the order of life.
And you say, well, unless you could say the word sudden has a specific meaning, for example, it means no longer than 3/4 of an hour. This is an evaluation by the tribunal in context of what a sudden outbreak is.
In my respectful submission, anybody
So it's not law at all?
It's not law at all.
Yeah.
It's not law at all. In my submission, that sounds defensive with me starting with this. It's not intended to be. This conclusion is plainly correct, if I may respectfully say so.
No.
And it's correct as a matter of common sense from a dictionary definition, but it's also correct from a contractual context of, for example, and your lordships have already made reference to this in my learned friend submissions, when one looks at the hours clause, and I'll come back to the hours clause in more detail when we get to the second issue. But this conclusion is plainly correct, but in any event, it is impossible to see, with great respect, how this gives rise to an error of law, unless your lordships are going to be persuaded by my learned friend that somehow catastrophe has some definitional requirement, such as, for example, it must either cause or be capable of causing property damage. And there is no warrant for that definitional requirement, either in the dictionary, and everyone agrees that there's no such definitional requirement, or contextually. Because the common ground, and I'll come back to this again, its relevance may be more acute in the light of the argument in the second issue now, but contextually, the arbitrators made findings which are set out in the award at paragraph 26, pages 9 to 10 of the supplemental band. It's really the top of page 10. These are either agreed or unchallenged on the basis of the expert evidence. So, little one, there is not a common market-wide understanding or definition of what constitutes a catastrophe. So, in other words, there is no common market-wide understanding or definition which is prescriptive in this area at all. Secondly, not disputed that non-property damage business interruption cover has been a common feature of many combined property business interruption policies since about the beginning of the 21st century, and is now invariably written by property underwriters alongside the property damage risk, both as BI cover consequential upon damage to property, and under an extension as cover for pure BI caused by perils other than damage to property. And then 3, it's not disputed that by the time the reinsurance was bound, any competent and experienced catastrophe excess of loss underwriter reinsuring a UK property book would or should have known that the business insured might well include both business interruption consequential upon PD and cover for interruption carried on at an insured property for a peril other than physical damage to the property. And then finally 4, which comes back to the later point, although Unipol disputed the approach was correct in principle, Mr. Coates' evidence not disputed, and there's the point that your lordships raised, which I'll come back to if I may. The arbitrators put it even higher at 59, dealing with the third point, paragraph 59, page 19, dealing again with the unchallenged evidence of Mr. Coates, page 19, my lords, paragraph 59, second sentence. Consequently, any experienced reinsurer underwriting the reinsurance would know or ought to have known that the class of business written in Covéa's property department, classified as household commercial, could and probably would include cover for non-property damage BI. So, well, this is the background to the question of whether or not the conclusion of the arbitrators that this is a catastrophe is somehow said to be constrained by a definitional requirement, not borne out of the ordinary meaning of the word, that somehow the catastrophe has to cause property damage or be capable of causing property damage. And we've set out our submissions in writing on that point. My learned friend didn't really put it at the forefront of his oral argument, but in my respectful submission, the argument is really hopeless. There's no basis for saying that a catastrophe, which is a word of ordinary meaning, unconstrained by an express definition of the policy, by market understanding, intended to be flexible, should contain that definitional requirement. And my lords, again, I want to take this fairly shortly, if I may, but this reinsurance, in using the word catastrophe, not only has not used the expression event with all the baggage or shibboleths or whatever one used to describe it, which as lawyers and indeed as reinsurers one knows no doubt all about. But the evidence before the tribunal, adduced by my learned friends' clients, not by me, page 17 of the supplemental bundle, paragraph 52, shows that in November, well, I'm not going to place, and I didn't place too much weight on this at the time, but it's more than a forensic tease. During November 2011, paragraph 52, Ince & Co wrote to a working party set up under the auspices of the International Underwriting Association to review the hours clause and advise specifically in relation to a proposal to replace the word catastrophe in the hours clause with event. Ince & Co referred to the case law on the meaning of event and recommended retaining the word catastrophe, as in the writer's view, it was more elastic and flexible. This is a view with which the tribunal agrees. And so far from somehow the word catastrophe having some, I don't want to say antediluvian, but 1960s or late 20th century meaning to be attributed to Mr. Kiln and his committee and so forth. The market was clearly alive to the distinction, possibly, between event, which had acquired all this judicial baggage by 2011, if not, in fact, by the time necessarily that some of Mr. Kiln's additions were being written, and an intention to use something more flexible. So, my lords, we say, taking the first issue as a gallop, and frankly, I'm conscious of that, so there's more to deal with it than your lordships, I'm sure, if you have any questions I can answer. But this was not, and deliberately not, it is reasonable to infer a reinsurance which used the word event. Mr. Justice Foxton did not, with great respect, think that it was a reinsurance dealing with the word event. In his judgment, you were taken, my lords, to paragraphs 104, subparagraphs in 104, and it was suggested at page 97 of tab 5 in the main bundle that Mr. Justice Foxton must have been, for example, in Little Roman 2, identifying happening in that paragraph with the happening which has the equating, in at least a colloquial sense, if not an aggregating provision sense, with occurrence. And with great respect, Mr. Justice Foxton didn't think anything of the sort, because if you go back to the previous page, under the heading, before paragraph D24, is a catastrophe a species of event or occurrence which must satisfy the axial field unities, and the argument based on axial field is set out. 99 Unipol relies on the use of the phrase loss occurrence, which it notes has been held to have the same meaning as event. 100, this argument is in some ways both the easiest and the most difficult of the issues raised on this part of the appeal. 101, the easy answer is that neither the Covéa Reinsurance nor the Markel Reinsurance uses the words loss occurrence or event, as the case may be, as a standalone term, but as a defined term whose meaning is set out in the hours clause. And just pausing there, my lords, in case you're mystified by that reference, the Markel Reinsurance didn't have the capitalised words loss occurrence, it had the capitalised word event. So that slightly explains the language of that. I am unable to accept the argument of definitional determinism, that's really a Markel point more, to the effect that the shorthand selected itself informs the meaning of the word beyond what it appears in its associated definition. And then 102, further, in the case of both reinsurances, there are factors which point strongly away from anything, but the most generous application of 2 of Lord Muster's 3 unities. And then the judge makes points, including in Roman 2, references to the hours clause. Again, the hours clause in Roman 3, Roman IV, common ground that bushfires would constitute a catastrophe, and yet, as the Covéa Tribunal notes, the notorious Australian bushfires developed in a variety of locations over weeks, if not months. And then, fifthly, finally, as Lord Briggs noted in his judgment, a hurricane, a storm, or a flood may take place over a substantial period of time and over an area which changes over time. And my lords, just pausing on that last Roman V, I don't place much reliance on it, but Lord Briggs, at that passage in the FCA test case, which was, of course, a dissenting judgment formally, in the sense that a minority judgment, let's put it this way, in terms of his analysis. But in that,
it's just a judgment which thought that the court of first instance might have got it right.
indeed.
Very powerful.
That's one way of putting it, my lord. But my lord, the reference is there. 323 is the paragraph number. It's tab 1 in the authorities manual. And at page 109 of the bundle, just after the citation of the sentence referring to the hurricanes over a substantial period of time, towards the bottom of 109, paragraph 323, Lord Briggs says, final sentence, "It is not, in my view, an inappropriate word to use about a pandemic disease as a whole, although I accept that it may be a point of some weight to an individual case analysis." And in a context where the parties have used the flexible expression catastrophe rather than the term event, not only is it a permissible, but in my submission is a perfectly correct use of the word catastrophe, both as a matter of language and in its contractual context, to say that what the arbitrators have held to be the relatively sudden outbreak of the COVID pandemic in the first 2 or 3 weeks of March was a catastrophe for the purposes of the reinsurance. Now, my lords, there are lots and lots of other points, obviously, that one could make to say that the arbitrators got catastrophe plainly right and on any view without any error of law. But unless there's any particular points that you would like me to deal with, I would really like to concentrate on the hours clause.
Just staying there a moment, is it a problem for you that the pandemic is still going on?
No, in my submission, no. And the reason why I say that, my lord, is this. At the end, if I can, as it were, invite your lordships to stand back and focus on what the nature of the relevant inquiry is in this case. Aggregation is about ultimately triangulating different individual losses back to some form of unifying factor for the purposes of a relevant aggregation provision. And of course, aggregation provisions are differently expressed. They can be event, they can be originating cause. They can't, in my submission, be happening. I've never seen it happening. But they can, in this case, be catastrophe. The key question, my lord, to answer your lordship's question, is whether what the arbitrators have identified as the relevant catastrophe qualifies as such without error of law for the purposes of triangulating the losses that we are seeking to recover. All of the losses that we are seeking to recover
All were in the first.
were first phase.
Yeah.
Were first phase. So the answer to my lord's question is that the way in which the arbitrators have formulated the catastrophe is sufficient for my purposes. Now, it would be no doubt possible to envisage many claims, and there are plenty of claims like this, where losses continued for a further period of time, such that it might well be said that as a matter of causation, the proximate cause of losses in September, I suppose the nurseries had stayed closed in September and October, or reclosed. One would certainly say on Stonegate principles and the approach taken in those courts, that those losses were proximately caused not by the initial outbreak in March, but by a subsequent phase or subsequent government measures or something of the like. At that stage, my lord, if that was the case that we were dealing with, one would need to ask, well, does the catastrophe need to be expressed more widely than the arbitrators have held? And the sort of question that your lordship has posed would become more acute. But actually, I would suggest, and this is going to come into the as clause in a moment, that that's likely to be an academic question, because it may well be that a subsequent closure of a nursery in September or October, a different business interruption caused by different closures, different cases, would not fall within the same loss occurrence window, even if one were to take a broader view of what the relevant catastrophe was. Obviously, that's going to tie in with my next set of submissions. But to answer my Lord's question, it isn't necessary to identify either the precise moment that something becomes a catastrophe, the hurricane out at sea, who knows, the bushfire, who knows when precisely it started, nor is it necessary to identify when it ended, or whether if the subsequent duration of this putative longer catastrophe caused fresh losses. So that's my answer to your lordship's question.
Now, what the tribunal found at 49 was that the exponential increase in COVID-19 infections in the UK during the first 3 weeks of March 2020 did amount to a disastrous sudden onset, such as to qualify as a catastrophe. That conclusion, I mean, quite apart from you say, well, that's all really an evaluation of the facts, quite apart from that conclusion, the fact that the pandemic may be resurging, as it appears to be at the moment, is neither here nor there, because it doesn't affect that conclusion.
It doesn't affect that conclusion, nor does it affect the triangulation that might. So that's my answer. And to be clear, just picking one further point out, the arbitrators have conspicuously not said. They might have said the COVID pandemic in that first phase more generally was a relevant catastrophe, but they've actually drilled down rather more specifically in terms of time and place to the UK, to that period of time with exponential growth of rates. And we say, answering my Lord Justice Newey's question, the fact there may be question marks at the end of the process is neither here nor there. So, my Lords, that is all I want to really say on catastrophe. But I perhaps just one further point, which ties in with the question of both catastrophe and also the as clause, is and also the proposition that this is an appeal on a question of law beyond which my learned friend cannot, as it were, trespass, is that causation in this case was conceded. And this is important both for my learned friend's point, which is a bad point, which I haven't laboured, which is that it has to be a state of affairs rather than an event, because only an event can directly occasion the losses. It's a bad point because, as my Lord Justice Popplewell pointed out, it's presenting as a binary choice or a binary dichotomy between two things when there's no basis for such a dichotomy. But this is also going to be relevant to the as clause as well. So I just want to focus on this, my lords. The questions of law that the arbitrators were asked to determine set out at paragraph 8 on page 3. Question 1, which is the catastrophe question, was the outbreak, propagation and spread a catastrophe within the meaning of condition 2.1, taking account inter alia of 1, this being a property catastrophe excess of loss reinsurance, and 2, the nature of the causal relationship between the type of individual losses and the catastrophe relied upon. And the third question, forgetting question 2 for the moment, this is the as clause. If the answer to question 1 is yes, then for the purposes of condition 2 of the XL reinsurance, where the insured first sustains indemnifiable business interruption loss within a nominated 168-hour period, but continues to sustain such loss after the said period, whether continuously or otherwise, does such subsequent loss fall to be aggregated with the loss sustained within the said period as part of a single loss occurrence, brackets, my learned friend didn't read this out, if all such loss arises out of and is directly occasioned by one catastrophe. And the answer that the Lordships, that the Tribunal gave to that latter question at paragraph 104.2 on page 31, I just ask the Lordships to go to that. 104 subparagraph 2, page 31. For the purposes of condition 2.2 of the reinsurance, where the insured first sustains indemnifiable business interruption loss within a nominated 168-hour period, but continues to sustain such loss after that period, such subsequent loss falls to be aggregated with the loss sustained within the nominated period of 168 hours as part of a single loss occurrence, if all such loss arises out of and is directly occasioned by one catastrophe. So causation, and by causation I mean arising out of and directly occasioned by causation, is built directly into the question and the answer on the as clause. And it was conceded. And I'll just give your lordships quickly take you to the passages perhaps before the shorter journal, if I may. Paragraph 43, page 13. Bottom of page 13, paragraph 43. It is convenient to deal with causation before addressing questions of construction. It was not disputed that the pandemic was a proximate or effective cause of the interruption to policyholders' business and of the resulting losses sustained during the first wave of infections, notwithstanding the immediate cause of such loss was the advice or instructions to close schools and nurseries. There's then a citation from the FCA test case, and the italicized or the emboldened text there, human actions not generally regarded as negative in causal connection. And then going back to the arbitrators, action taken by the UK and national governments to delay the spread of COVID was undoubtedly controversial. It's not suggested it was wholly unreasonable or erratic. It is accepted, therefore, that it did not negative the strong causal connection between the outbreak or development of the disease in the UK in the period preceding the closures and the interruption and resulting loss to the businesses conducted from the premises affected. My Lord, same point at paragraph 58, page 18, where in the second sentence of paragraph 58, as noted above, it's not disputed that the pandemic in the UK was an effective or proximate cause of the closure of schools and nurseries. As such, it led to a loss affecting commercial property by hindering or preventing access and causing loss of its use. And then finally, on this point, my Lords, 100 to 101, which is on page 30, we're dealing with the hours clause now, my Lords, not dealing with the catastrophe point. The arbitrators say, paragraph 100, in theory at least, difficulty of causation could arise more readily in a case of losses caused by a catastrophe consisting of the explosion of COVID infections in March than in the case of losses caused by a catastrophe such as a hurricane. And they sort of address the point my Lord Justice Newey put to me in his question. And then again, the final sentence of this paragraph, however, it was common ground in this arbitration that the outbreak or development of COVID-19 that caused the closure of nurseries on the 20th of March had a continuing causative impact throughout the first lockdown until nurseries were allowed to reopen as restrictions were gradually lifted by the UK and various national governments from June 20 and then 101. It's not disputed, therefore, there was an unbroken chain of causation between the outbreak that caused the closure of nurseries and I'm not going to read the whole of 101, it's to the same effect. Yeah. Now, that's going to be important to the argument which I'm going to develop, my Lord, probably now after the lunch break, But can I just identify to your lordships before you rise, obviously I'm going to develop this argument, but the fundamental flaw in my learned friend's argument on the as clause is it conflates and confuses the individual loss with the financial losses being suffered by the policyholder, which form part of or comprise an individual loss. The critical question for your lordships, and I will develop this afterwards, but the critical question for your lordships is not, does an individual loss have to occur within the relevant loss window? We've always accepted it does. A paradigm example of a hurricane striking, if a hurricane strikes on day 1, but somewhere else on day 8, for example, making sure I've got the, well, it's 120 hours, it doesn't matter for these purposes, those two individual losses would fall into different loss occurrences. But the fundamental vice, in my respectful submission, which both the arbitrators and the tribunal identified, is that one's looking at when an individual loss occurred, not when aspects of that individual loss, be it the property damage aspect, the business interruption loss in a PD case, or the business interruption loss in a non-PD case occurred, nor when the financial losses resulting as a part of that were suffered. That's the vice. And I'll come back to that, if I may, at 2 o'clock. But that's the battleground which your lordships will have to decide.
Okay. Right, 2 o'clock.
Court rise in favour.